Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give me attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you and good morning, everyone. Let me begin by introducing your panel to you. To my right is Justice Marguerite Grant. To my left is Justice Maureen Walsh, and my name is Ariane Vuno. We have a short list today, only 2 cases. I want to remind everybody that each side has 15 minutes to make their argument, and there is no rebuttal in the appeals court. The first case on our list is an impounded case, and so I just remind the parties not to use any names. The number of the case is 2022-0679, Department of Children and Families versus Father and Another. And I understand the appellees are sharing their time 9 minutes and 6 minutes, respectively, correct? All right. All right. We're ready to hear the first case.
Thank you, and good morning. First, Justice Bono, Justice Grant, and Justice Walsh. May it please the Court, my name is Dana Schoenevert, and I represent the appellant father. And what this case really turns on is the lower court's erroneous finding of parental unfitness, or the father's parental unfitness, without first taking into consideration the omissions by the Department of Children and Families. One of the grounds for the finding of unfitness pertained to father's lack of engagement in services. Now, the reason why this does not clearly and convincingly prove father's unfitness is because he was not given the opportunity to engage in those services. His social worker met with him for the very first time in December of 2020. The case had been ongoing since July 2019. So the first time...
Was your client aware of that? Your client was aware of the fact that the child was in DCF custody, is that right?
Yes. My client was at the hospital at the time of the child's birth. However, there was a very real question about the paternity of this child. Mm-hmm. And father expressed his concerns up front when he came to the hospital and said, if this child is mine, I am fully committed. And on November 4th, 2019, the docket reflects that father did, in fact, initiate a complaint to establish paternity in the probate court. Now, the record doesn't indicate that the delay in the adjudication, which took 13 months, does not indicate that father had anything to do with those delays. So filed the complaint November 4th, 2019. He was adjudicated the child's father 13 months later on November 13th, 2020. So at the time of the child's birth, he was there, ready to be engaged if this child was his, which no one knew. But the department did proceed as if paternity had been established. Mm-hmm. For the first 3 months of this child's life, my client did have visitation. Now, much ado has been made or was made by the lower court about the father's indifference towards the child during the child's majority of the child's life. The child was 2 at the time of trial. However, he didn't know whether this child was his. But he did. He visited with the child for the first 3 months of the child's life. Father testified that he had 4 or 5 visits prior to his incarceration in July 2020. However, the foster parents or the pre-adoptive parents testified that father was engaged in weekly visits with this child, missing 2 non-consecutive visits during that first 3 months. So there's a reasonable inference to be made from the record that father had much more contact with this child than the department or even the child herself has alluded to in their respective briefs. So
we know anything? I noticed that the 51B report in July of 2019 included action plan tasks for the father, including complete the anger management program and present DCF with a plan for caring for the child if he chooses to try to reunify with her in his home. Do we know if what he did during that time to accomplish those tasks?
So beginning in 2019, father was visiting with the child. The record is not clear on the services that he completed prior to his incarceration, but he did testify at trial, an unrefuted testimony, that he completed a course that included anger management programming while he was incarcerated. So, the service plan that is in evidence, however, is dated March 25th, 2021, and that is the service plan that father signed. It's unclear on the record what the prior social worker, the level of involvement the prior social worker had with my client, but the fact that he had his first contact with DCF in person in December 2020, I believe is very telling that the department...
Other than the emergency response worker.
Other than the emergency response worker, who they were both at the hospital. Father had stayed the night, he was there, and she interviewed him at the hospital where he expressed his hesitance to fully engage until we knew the paternity of the child.
Do we know if there was a DCF worker present at those visits that your client had with the child? I think there was something about them happening at a DCF office during the first year or so of her life?
During the first 3 months of the child's life, yes, those visits, the record indicates that those visits took place at the DCF office. It doesn't say expressly that the DCF social worker supervised the visits, but definitely the foster parent testified that they were involved in those first 3 months and that the visits stopped in November 2019.
Can we focus on where the trial court erred, in the sense that admittedly your client indicated that he was going through some things, right? And he had very limited interaction for a significant period of the young child's life. And then a service plan was offered, and I understand your argument with no resources, but am I wrong in reading the record to say that he didn't take the parenting classes that were suggested, that he didn't take any drug screens, or he didn't provide any proof that he did a substance abuse program? If those facts are true, minimal interaction, periods of time where he was not present, combined with a failure on his part to engage in services that would make him a better custodial parent, where did the trial court make the mistakes?
The mistake was the finding of parental unfitness, the finding of him not having engaged in those things, without considering that DCF did not meet its obligations under his service plan. During that home visit, the first and only home visit that occurred 2 weeks before trial, the social worker said, I will give you a referral so you know where to go to the correct parenting course. Because he had already done a parenting course, it wasn't the right one, according to DCF, so she says, I'll give you a referral to another one. The substance eval, he says, I've done it, I think, I'm open to doing another one. The social worker says, I'll give you a referral to get that done. She kind of generally referred to the urine screens and said, I want you to do these things. But again, there was no specific guidance on where to get those things done, how to get them done, how frequently, who was going to pay for those things. So she says, I'm going to give you information on how to do these things, but first, I'm going to go on a 2-week vacation, and I'm not going to come back until the morning of trial. And meanwhile, I'm going to leave your case idle. She didn't delegate those responsibilities to anybody. While she was away for 2 weeks on vacation, there was no movement on father's case. He did not receive those referrals. So I would say, and there was no indication, there was no consideration of this in the judge's findings, and I would say that the finding of his unfitness based on the absence of the completion of those tasks was erroneous.
Okay, thank you.
So, and I know that, this is somewhat of a reasonable efforts argument, which, was not raised below, which is waived under precedent.
Just a second while he fixes that for you. That's all right. It was inadvertently typed touched while you were making your argument, and so now he needs a new pad.
Thank you. I know that the argument for reasonable efforts is waived. However, I think the extraordinary circumstance here is that, DCF has an obligation, and DCF needs to be held to task to meet their obligations. And where they don't, and where there's a finding of unfitness based on those omissions, that needs to be considered by the lower court, and those determinations need to be reviewed by this court. Just fundamental fairness, principles of fundamental fairness would require the court to at least look at what DCF didn't do. As far as the sibling visitation, I wanted to touch on that. It was remarkable to me how, we have a biracial child. That is in the record. The mother of the child, now deceased, is Caucasian, white, and the father of the child is black. The child has siblings on both sides of those families. The foster parents testified, there is evidence in the record that the subject child had meaningful relationships with her maternal siblings. Now, father's interaction with this child was intermittent. It was not consistent for various reasons. However, there was an older sibling, a half-sibling of this child, that attended a visit in April 2021. And there's evidence in the record that father actually had 3 other children, aside from this one that visited in 2021. So the error here is that there was no best interest consideration for the paternal siblings, which under chapter 119, section 26B, subsection B, the court is required to consider whether sibling visitation is in the best interest of all children. Now, there need not be evidence presented. I don't know where case law, there's no precedent to say that evidence needs to be presented for the judge to make this consideration of whether the sibling visitation is in the children's best interest. But what I do know, based on the cases that I read, Pierce, for example, it is very similar to this case. However, in that case, the judge made a finding and actually considered whether visitation was in the children's best interest. And the error here is that analysis was not done, and it needed to be. So those are the 2 primary issues that I wanted to address with this court. And if there are no further questions from the court.
Just check with the panel. Seeing no further questions, thank you very much for your argument.
Thank you, Your Honors.
Good morning, Your Honor. Carol Frizzoli on behalf of the Department of Children and Families. This case demonstrates a father who has never made parenting this child a priority in her first 2 years of life, having minimal involvement with his daughter for a total of 6 hours spent with her prior to the trial, was incarcerated during the majority of her second year of life, and did not engage with the department and participate in any supportive services, not even knowing at trial his daughter's correct birthday or any special needs that his daughter might have. The unchallenged evidence before the trial court demonstrates that father's unfitness was not temporary and likely to continue into the future based on his overall indifference to his daughter over the course of this case. This child in this case has significant needs, has been placed in a pre-adoptive home that is addressing those special needs and deserves permanency. While present at his daughter's birth and initially engaging with the department for visits with his daughter, father self-admittedly disengaged with both contact with the department and visiting his daughter. He was admittedly couch surfing during his daughter's first year and missed 2 out of the first few scheduled visits. During his daughter's second year of life, he visited during her second year of life, the father was incarcerated. He self-admittedly said he didn't contact the department for 5 months while incarcerated.
I have a question.
Sure.
Before you get that far ahead in the chronology. In the 51B, there's a letter dated July 18th, 2019, from DCF to the father, saying that DCF was going to do a family assessment. Do we know if that was done? Is it in the record?
What was done in this case was, again, father at that point challenged paternity, which absolutely understandably, in November of that year, the juvenile court record reflects that there was a motion for genetic marker testing. But also at that point, father actually proposed his brother, and an ICPC was begun on him. And then the father, self-admittedly at trial, said he withdrew that request because he wanted to take custody. So his brother, who was out of state, there would have been, they actually had begun the ICPC process to see if the brother was a suitable candidate. So the family assessment, again, with respect to the father, while he was challenged paternity, he self-admittedly only was involved with the department for the first 3 months of this child's life, and then withdrew because he said he was working through some things, stopped contacting the department, and then lo and behold, became incarcerated. And then upon incarceration, for the first 5 months of his incarceration, didn't reach out to the department. At that point, the social worker from the Bill Ricker jail did reach out to the department, and they did set up video visits, which unfortunately, because of the child's age and the setup, they only lasted, there were a few, and they only lasted approximately 10 minutes each. Then the father is released from jail in April of 21, prior to the trial, for 60 days. Prior to trial, the father did not engage in any services. The department was the one who reached out to the father. They scheduled 2 visits, in-person visits, and he missed both of them. There was 1 visit prior to trial. That's where we get the total of 6 hours that he spent with his daughter prior to trial. So, in addition, Your Honor, although I agree that reasonable efforts was never raised at trial, and my sister brings it up, it is a valid point. The department needs to work with these families. But in this case, the father did not engage the department. The focus on this case has to be on the parental current ability to assume parental responsibility, not whether the department adequately provided services to this family. What really, lo and behold, probably most likely happened in this case is, as the father testified at trial, he's the father of 4 other children, and he has never been the primary caretaker with any of these children. In this case, the focus was most likely on the reunification with mother, and unfortunately, mother passed away in June of, prior to trial. So again, but up until the trial, the father was aware since July 2020, when the department changed the goal to adoption, and father took no action to remedy that effect. So in addition to that, we would request that the decision be affirmed because the trial judge didn't have any error. I would like to address the sibling visitation issue. With respect to the paternal, so there was no sibling visitation order issued in this case because the foster parent testified, and the trial judge felt very confident with the pre-adoptive parent's testimony that they were going to foster a relationship with the mother's other children. Now, with respect to the paternal side, these other siblings, number one, it was never raised. It was never requested by father that a sibling visitation order be placed, so therefore it's waived. But even if you could say that it wasn't waived, because we have our sibling visitation statute, in this case, these are paternal relatives who aren't part of the jurisdiction of the juvenile court. Inree Jamison tells us that the sibling visitation statute applies when there's state intervention in a case. We don't have anything in the record here which indicates that these children were separated via state intervention. In fact, they're in the custody of their mothers, according to father. So how would the juvenile court possibly be able to issue a sibling visitation order that mandated visitation with paternal's side of the family when they weren't even part of the underlying case? So with respect to that, unless Your Honors have any other questions, I would rest on my brief.
Okay. Seeing no further questions, thank you very much.
Thank you.
All right. Counsel for the child?
Good morning, Your Honors. May it please the Court. The child would ask that you affirm the judgment of the lower court in all respects. Contrary to father's belief that his obligation to parent this child started at her mother's unfortunate death, he was obligated from the moment she entered state custody the day after she was born, a substance-exposed newborn. Despite being told he was the father, he denied paternity and took a year and 4 months to establish paternity. The clock did not begin to run in this matter when father was released from incarceration in April 2021. It started the day the child was placed in the department's custody in July 2019, just 1 day after she was born, and father was well aware of that. By the end of trial in August 2021, my client had spent her entire life, 25 months, in state care, and her father had only spent 6 hours in person with her. The court found that there was clear and convincing evidence of father's unfitness, excuse me, and there were a combination of factors that contributed to the termination of his parental rights. He failed to consistently and meaningfully visit with the child to build a relationship. He failed to consistently and meaningfully stay in touch with the department or participate in supportive services. He never made parenting her a priority during the 2+ years she was in state custody, at times even admitting he was not able to parent her. He dropped out of contact with the department shortly after her birth and waited over 1 year to establish paternity. He was unavailable to her due to his criminal activity and subsequent incarceration. He failed to participate in a substance abuse evaluation, which the court found was a reasonable task, given the evidence of his prior participation in drug rehabilitation for marijuana use and his open charge at the time of trial of operating under the influence of liquor. He failed to participate in urine screens or stop using marijuana. He failed to participate in a parenting class designed to assist in learning her needs. He failed to maintain stable housing at any point during the case. These failures persisted from 2019 through the time of trial, and it was reasonable for the court to find that they were not temporary. Given his lack of contact with the child, the court found he was unable to understand her special needs and her medical needs. Father also does not seem to comprehend that the pre-adoptive home she is in is the only home she has ever known and the only parents she has ever known. She is bonded to them, and she deserves permanence. If there's no other questions, I'll address the sibling visitation issue.
Please go ahead.
Thank you. The judge found that the pre-adoptive parents would continue to facilitate contact with the child's siblings. He appears to have left the matter open to future revision or possibility of contact with both sides. He did not specify maternal versus paternal. After hearing testimony from the pre-adoptive parent, he felt confident that an order issuing a finding that the pre-adoptive parent would continue to maintain the relationships that existed, that is what the court found. And the court is entitled to weigh witnesses' credibility and witness testimony. The child agrees with the department that the statute is inapplicable. However, even if applicable, it was neither reasonable or practical to fashion an order for my client to start doing something that she has never done with siblings she has never met. There is no relationship to nurture, foster, or maintain. Further, the issue was not properly raised at the trial court level and therefore waived. No post-trial motions were filed or no motions for reconsideration regarding paternal sibling visitation were ever presented to the trial court. The child would ask that you look to the plain language of the statute and the words separated through foster care. My client was not separated from his paternal siblings. There's a brief mention within the record that father's oldest child was present during a Zoom meeting. There's no record evidence that that child interacted with my client or that my client knew who that child was. Further, an order ordering post-adoption visitation with my client with paternal siblings at this point, given the record evidence, would run contrary to the spirit of the statute, and surely the legislature was not contemplating a non-existent relationship when drafting this legislation. Like many families with fractured families, and half-siblings, there is not always contact, especially given at the early stages of my client's life. Sometimes it occurs later in life when siblings reach out. Further, there was no evidence presented that it would be in my client's best interest to have those visits. In Edgar, although it's a parent-child visitation case, the language there indicates that the judge is to evaluate the present state of emotional bonding. So in this case, there was no bonding between the paternal siblings. There was bonding between the maternal siblings. And my argument would be, should the sibling relationship be elevated to more than that of a parent-child relationship? If you need to find a bond with a parent and a child to order visitation, I would suggest that you need to find a bond, or the court needs to find a bond between the siblings in order to fashion that order. Father, throughout this case, the full 2 years, did not foster a relationship between his children and my client. They were not included in any other visits other than that one Zoom, 10-minute Zoom. To my knowledge, and the evidence on the record is devoid of any requests by father to have his other children participate in visitation, especially those in-person visits.
Your time is actually up.
Oh, my apologies, thank you, I wasn't watching this clock.
That's fine, but
Thank you.
anything you didn't mention that's in your brief, of course, will still be considered.
Thank you very much.
All right, no problem. I want to thank everyone for coming here on this case. These cases are always very difficult. We take them very seriously. We reviewed the record meticulously, and we'll get back to you as soon as we can. All right, thank you. All right, we're ready for the next case on our list, which is case number 2022-0655, the Colotos Family Partnership versus Athena Capital Advisors. And I may have mispronounced the name of the family partnership, and you can correct me, or we can just refer to it as CFP, as you have in the briefs. Everyone settled? All right. Good morning. Please begin.
Good morning. May it please the court, my name is Charles Waters. I represent the plaintiff and appellant Colotos Family Partnership. I'll call it CFP.
Okay.
And I'll also call the defendants Athena Capital Advisor, ACA, just for ease. Mm-hmm. Your Honors, this case is about an LLC member's efforts to obtain books and records pursuant to a specific contractual right in an LLC agreement. The LLC agreement here provides the board for ACA with discretion to conduct the LLC's business without interference from members. Now that's subject to the member's right to oversee the financial and accounting documents. That's the balance that the parties agreed to from the outset. Now in 2020, CFP requested information and records about financial, accounting, and tax information. At first, ACA misled, deceived, and hid information from CFP that CFP claimed was a breach of fiduciary duty. Later, ACA took the position that CFP could not have access to any records because CFP's rights had been terminated in a merger agreement that CFP had nothing to do with. So CFP filed this lawsuit. In two different rulings on two different issues, the trial court committed error in dismissing all of the counts. In this appeal, CFP now asked this court to reverse those two rulings and to remand for discovery. Let me start, if it pleases the court, with the motion to dismiss decision. The motion to dismiss, on a motion to dismiss, the trial court dismissed the breach of fiduciary duty claim. We believe the court erred in two ways. In the first way, it used as a breach of fiduciary duty standard Delaware case law relating to asserting facts that establishes either a fraudulent, wrongful, or unfair acts. That's the standard in Delaware. Here, the court erred in only looking at the first two, fraudulent and wrongful acts, and not analyzing these facts under the unfair acts standard. The
The
second,
so-called third prong, is that what you're saying?
that's the third prong, yes, Your Honor. The second way that the trial court erred on the motion to dismiss is that it ignored the pled facts, the inferences that it reasonably should have drawn from those facts, as well as, and this is important, the context and the totality of the circumstances relating to all of the facts and inferences that were asserted. And what I'd like to do, if it pleases the court, is just walk through what the court should have found for facts and inferences. We believe the court should have found that prior to February 2020, that CFP told ACA about its concerns regarding specific financial transactions it was making. After that, ACA set up a series of transactions it believed would strip CFP of its rights to ask for those documents concerning those financial transactions. In February, and specifically on February 23rd, 2020, ACA provided legal documents. Now, the legal documents that I'm referring to is at the appendix record, volume 1, between pages 233 and 259. Those are the documents that ACA provided to CFP on February 23rd, 2020. And we believe that those documents, put into context of every other fact that's alleged, demonstrate that there were unfair acts committed. And let me just walk through some of those documents.
On the basis of the alleged releases and things of that nature that were contained in those documents? Is that what you're referring to?
Sorry, I missed the first part of that, Your Honor.
In reference to the alleged releases and things of that nature that were contained within the documents you're referring to?
That's exactly right, Your Honor. Yes. And I will say that that document was sent with an email from ACA, specifically its counsel, that said that the documents needed to be signed by the next day. Now,
Didn't the judge consider that?
I'm sorry?
Didn't the judge consider that in the first motion?
The judge considered it, but as a single fact. And what I'm suggesting for this panel is that that's a single fact that may not in and of itself lead to the conclusion of an unfair act, but taken in the context of all these other facts certainly does. And the inference from the email saying, sign this by tomorrow if you want your money back at the closing, the inference there is that ACA wanted to put pressure on CFP, undue pressure.
Well, do the documents mean that if you don't sign by tomorrow, you can never get your money back?
I don't read it like that, Your Honor. But everybody wants their money back, and everybody wants their money back right away. And I do read it to mean, if you want your money back right away and don't want to delay or go through other paperwork, do it now. And I think that puts undue pressure, which was purposeful, undue pressure on CFP to do two things. One, to not review that document itself, and two, not have your attorney review that document, because it knows that the chances of getting an attorney to review a stack of legal documents within 24 hours is almost impossible. So it knew what it was doing, and that's the inference.
In CFP, just so I'm clear, didn't sign that release, correct?
Correct, correct. So they also, in the email, said that these documents were typical and required, both of which, again, attempt to put this pressure on CFP. Now, the documents that ACA attached demanded that CFP sign a representations and warranties section of the document. And none of the representation and warranties section could a CFP actually make those representation warranties? And ACA knew that, and let me give you a couple of examples. The representations and warranty that ACA was requiring CFP to sign required CFP to agree to payment for its membership interest pursuant to a calculation contained in the merger agreement. Well, ACA knew CFP did not have the merger agreement, and so did not know what that calculation was in the merger agreement. The representations and warranty also required CFP to agree to, quote, execute any additional documents. No specificity, just any additional documents that we need for you to execute for you to release your obligations to ACA. Another one required CFP to agree that ACA can withhold additional money. Didn't specify about how much, when, how, under what right, nothing. Another representation that ACA wanted CFP to sign to get its money back required CFP to agree to an appointment of a representative to act on its behalf pursuant to the merger agreement and the escrow agreement, both of which ACA didn't give CFP and knew CFP did not know about. So those are just the representation warranties. Then there's another part that relates to specifically the release. And as this panel knows, we believe it was an overly broad release and that CFP wanted it to sign it. But there was some language in that release that was a representation that ACA wanted to make CFP make. And specifically, that representation was that CFP had an opportunity to investigate and did investigate to its satisfaction. Now, including, and by the way, it knew, ACA did, and this is the inference, it knew that CFP didn't investigate because it didn't have any documents to investigate. It did not know what the merger was. It did not know, for example, that there were 4 different entities created, that there were 2 different individuals involved, that there were 3 different agreements pursuant to this, and that there were a series of transactions to create this merger. CFP knew nothing about this, and ACA.
Why does CFP need to know that information about the merger, about what's going to happen after?
Because in this case, CFP was allegedly going to lose all of its rights and only receive back a certain amount of money. So CFP certainly had a right to investigate whether that was fair. How did ACA come up with the fact that, hey, ACA was going to keep all of my money for 13 years, and after 13 years, merge, terminate all your rights, and only give you your money back? No interest, no disbursements, no nothing.
Did ACA need the consent of CFP for the merger?
No, because, and this is part of the balance, Your Honor. The
Right.
balance was CFP gave ACA all of the authority to do whatever it wanted to run its business.
So if CFP isn't required to consent to a merger, how is this information important or relevant to your claim of breach of fiduciary duty? Sure, it may be overbroad language. It seemed pretty broad in my interpretation, but if at the end of the day, ACA doesn't need CFP's consent to merge, I'm not entirely clear why these documents matter.
Yeah, thank you for your question, Your Honor, and it's a good one. And I would say that when ACA gave these documents to CFP, it was a heads you win, tails you lose. Heads I win, tails you lose situation. Either CFP was going to sign that release, sign those documents, and ACA would terminate all rights that CFP had, or the closing would come up so that if CFP looked at the language about having an opportunity to investigate and took any steps to investigate, that closing was going to come up, and ACA knew it was going to take the position, all your rights are terminated. We did it. We distracted you. We obstructed long enough. We did it. The closing happened a matter of days after this package was sent. ACA knew that it only had a matter of days to obfuscate what was going on, so that by the time it closed, it would take the position that CFP could never investigate what they had offered CFP to investigate. And so the offer to investigate in the release was always illusory.
So because CFP requested the books and records, your claim is, if I understand it properly, and I mean this, please correct me if I'm inaccurate or I'm somehow misstating your position, that ACA went through this whole process of merger just because CFP wanted to look at the books.
I wouldn't argue that, Your Honor. What I would argue is that they knew what they were doing. They didn't want to hand over any documents, books and records, financial information about how they were making distributions or giving benefits to other members that they weren't giving to CFP, because those were the questions. And that they figured out the best way to do this. And mind you, there's a handful of members. This is not a massive entity. There's a handful of members. The best way they figured out to do this would be just simply to go through a merger agreement, terminate everybody's interests to avoid any rights that CFP or anybody else had, as a way to avoid any scrutiny that was bargained for in the LLC agreement. Remember, they weren't going to get, they had the authority to take whatever steps that they wanted to do, but that was balanced with this oversight authority of looking at the books and records.
And I see that time is short. I wanted to focus a question at least on, in conjunction with your 56F motion, why didn't you file a motion for an opposition to summary judgment at that time? Was there anything to prevent you from doing that?
We asked the court if the court wasn't going to give us more discovery.
For 30 days.
We asked for 30 days.
Right.
And we thought that that was reasonable. The court didn't identify any reason why extending 30 days wasn't reasonable. We had hoped, of course, that we would get discovery and we could actually, on the merits, file an opposition.
No, I appreciate what you hope for, but was there a plan B? In other words, that if all of your requests were denied, at least you had, was there anything to prevent you from filing an opposition for a motion for summary judgment in conjunction at the time that you filed the 56F?
Other than it would have been a dramatically incomplete opposition that we would then later on potentially being held to argue only those positions instead of being able to challenge the discovery, the defense that ACA had, which we thought we had a right to challenge that defense, and then that we would have a full on the merits opposition. And to be handcuffed by not being able to challenge that seemed like if we filed an opposition, it would be dramatically incomplete. I guess that's my long answer to your short question.
All right, so the answer to that question took you a little bit over your time, but I'm going to see if there's any additional follow-up questions. No. So thank you for your argument, and nothing is waived. Everything in your brief will certainly still be considered.
Thank you, I appreciate it. Hands are falling. Sorry about that.
May it please the court, my name is Robert Kaler. I'm a partner with Holland & Knight law firm, and we are counsel for the defendant appellees, Dr. Lizette Cooper and Fiduciary Trust International, LLC, which is part of the Franklin Templeton group of companies engaged in the investment advisory business. Before it was acquired by Franklin Templeton 3 years ago, Fiduciary Trust International, LLC was known as Athena Capital Advisors, LLC, and it was managed by Dr. Lizette Cooper. It was her company. She'd founded it a little over a decade earlier. And
So, counsel, we've taken almost a whole minute in introducing who the parties are. Let me focus on one of the issues here. In essence, Did you file basically a motion to dismiss, a second motion to dismiss, dressed in sheep's clothes, a motion for summary judgment?
No, we viewed the decision on the motion to dismiss as an invitation to move for summary judgment on the only residual issue that was still left after the motion to dismiss was decided, because the rationale that the court gave, that Judge Green gave in her decision, was, I don't feel comfortable considering the merger agreement at this juncture on a 12B6 motion because the allegation is that they didn't have it when they pled their complaint.
Do you think that the original motion judge could have considered that merger agreement?
Well, I thought that the case law supported the proposition that she could consider the merger agreement because it was referred to in the complaint. I guess perhaps I didn't dissect the case law as much as Judge Green did. And it seemed, however, that the references in the complaint were in quotations. So I thought, yes, in good faith, that she could consider it. And that's why we made the motion to dismiss at the time. Because bear in mind that a couple of months before the suit was filed, the defendant, the plaintiff, had made requests for books and records that were being made several months after the merger had occurred. So under Delaware law, they had no right to the books and records, and they were asking for books and records going back a decade.
So, but it's just such an early point in the lifespan of this case, and that may be appropriate and correct, but my question is in essence, there was no opportunity for discovery. So plaintiff files a complaint that has some allegations of general wrongdoing, general breaches of contract, fiduciary duty, implied covenants, etc., yet is prevented from ever discovering whether there's any truth, any documentation, any evidence to support other than their good faith belief that something's going on, because if we're to believe, and that's a standard, right, to believe what's in the plaintiff's complaint, as soon as CFP started asking for information, it was like,
well,
there the merger happens.
That's, from our standpoint, a spin that was put on the facts. And there's a critical fact in the appendix at page 97 which influences all the inferences to be drawn in this case. And we all know that the reasonableness of inferences depends not just on the specific facts pled, but the circumstances under which they're pled. If someone's charged with robbing a bank on a Friday afternoon and they're seen in a coffee shop next door 45 minutes before the robbery, but there's very little forensic evidence, maybe suggested, you could draw a lot of inferences from that. On the one hand, if the person lives down the street, stops at that coffee shop every day, and has his spouse is working there, or her spouse is working at the coffee shop, then there's not much of an inference there. If they're from out of state and they never appear there and they have no reason to go to the town, it's a different inference. What's the key fact here? The key fact here is that 7 years before this merger, at page 97 of volume 1 of the appendix, there's an example given. It's an example given in the Second Amendment to the LLC agreement. It says, if we sell this company and we get less than $30 million, you, Koleidos, will get back $500,000, and that's all. And he signed that. His signature appears 2 pages earlier on page 95 of volume 1 of the appendix. His complaint was a whole series of allegations that were not sufficient under Delaware law. We moved to dismiss, and the motion was granted. It took 8 months, but that's okay. Our fundamental position of the defendant appellees here is that the business litigation session into which we transferred the case at our motion early on did exactly what it's designed to do, which is to apply Delaware corporate law concepts and other types of concepts to this case. So it took 8 months. Our position is she got it right, and I expected them to amend. They could amend as of right. I didn't jump in and file my answer. I waited 20 days, expecting them to amend, and they didn't. Even if they'd gone past it, I'd filed the answer and they'd moved to amend. I don't think I could have opposed it. How? They didn't amend. Those allegations that they make, and in their reply brief, I'll just address the point that you were making, Justice Warren. They make allegations in their reply brief that describe what Mr. Clevin, Athena's counsel, did as a scheme. And I wrote some notes. This was all done, we've alleged facts that they acted in a manner designed to manipulate CFP into agreeing to a scheme designed to eliminate CFP's interest. CFP didn't have to agree. The scheme was a merger that they're permitted to do. I described the inferences that they wanted the court to draw in our appellate brief as paranoid. You can't use the reasonable inference doctrine as a license to just say that perfectly innocent conduct that's perfectly consistent with being at the coffee shop because you're there every day, conduct that is like presenting a release document to someone and requiring them to sign it because the merger agreement requires it, and just saying to them, look, if you don't sign it, we'll pay it to you after the closing. There was no coercion at all here. I recognize that the way it played out, there was no discovery. But our view was that they didn't have a viable claim, and they were using the lawsuit to try to get some discovery to create one. They didn't have a books and records claim, and that was the only part that we couldn't get dismissed on a 12b-6. It was my judgment to make the motion for protective order. In 40 years, I've never made a motion for protective order to stop discovery pending a motion to dismiss. I mean, in the securities context, we see it all the time, or it's a matter of statute. But it was weird. They had just been asking us for 2 months for books and records, and the email exchanges between Mr. Clevin and counsel are in the record. It just, to us, he wasn't making any sense. He was just saying, I want the books and records. We said, you're no longer a member. Your guy was a member for 10 years. He never made a books and records request then, and ancillary requests around the time of the merger that, okay, what is everybody else getting? He was told that. And so when we sort of dissected the complaint, it didn't stand up. And the discovery that we were hit with at the outset of the case was massive. More than I think that I've ever seen in cases that don't involve a preliminary injunction. Sometimes you see it in preliminary injunction. But with the complaint, there were forces, subpoenas, duces tecum, massive discovery requests for tax returns going back 10 years. Now, that's a circumstance from which one can draw some common sense inference. Someone wants to really look at a broad range of records, way beyond the fiduciary duty claim. And the one that they focused on in this appeal is just having to do with the merger. They wanted records of comp committee decisions 10 years ago. So I made the motion for protective order after I filed the motion to dismiss. And it's my view that in general, one is not entitled to that. I think the case law says that. You don't generally get up. But this was an unusual case. And it went in front of 3 judges of the business litigation session. Judge Davis granted the protective order. Judge Green granted the motion to dismiss, and Judge Krupp eventually granted the summary judgment motion. And I'll caveat my comment about our saying basically the BLS got it right at every stage, with just one caveat. There was one misstep in the summary judgment decision where the court referred to the result of the merger being a dissolution of what was Athena. It wasn't dissolved. It continued. It merged into another company. But that's immaterial to the issue of whether they had the right to do the merger. Mm-hmm. And sometimes I get confused myself looking at corporate documents. I do corporate litigation, and I have to go back and ask my partners, okay, did the original company survive or not? That's not material to the decision. But my point is, Judge Davis had the motion to dismiss in front of him because I attached it to the protective order motion. And I'm sure he was aware of the case law that says you don't automatically get a protective order on a motion to dismiss. Something was wrong with this complaint from the beginning. You can't, and the Delaware courts, I mean, there are dozens of cases where these claims are dismissed because people come in and minority shareholders are often complaining. I mean, I may be a minority shareholder in a lot of things, but if I buy 100 shares of General Motors and next year they say they're merging with RCA, I can't come into court and say, well, you prove to me that you have the authority to do that. The court will say, well, do you have any reason to think they don't? And it's that question that the complaint never answered, and that they never answered at the summary judgment stage either. I'll start just the motion to dismiss. I realize the standard of review is de novo, but in addition to the points that Judge Green made, she dissected the specific allegations, which is exactly what the Delaware courts do. And the cases we cited say that. So she really, and she took a little while to do it, but it was, I couldn't really take issue with the decision. And as I say, to come back to your first question, Justice Walsh, I felt like it was an invitation, as I say, to make the summary judgment. But before I did it, I talked to counsel, and I said, look, I think we have a right to do this. And they said, well, we want this discovery. Now, they narrowed their discovery somewhat, but it was still a very long list. My email is in the record. They wanted tax returns going back several years. They wanted financial statements going back 10 years. They didn't narrow it very much. And so I had to make a judgment. What do we do at this stage? The complaint is deficient. As near as I can tell, if I can get the court to consider the merger agreement, then I think the books and records claim falls apart because they clearly weren't a member.
As I understand the books and records claim, CFP is saying, we put $500,000 into this company, and 12-plus years later, we're only getting $500,000 back. We want to see the books and records to make sure we've been treated fairly. What's wrong with that analysis?
Well, the problem is, number one, it's an investment advisory firm, not an investment fund. So that the investment advisory business is very, very competitive. If you invest money in it, you're not necessarily going to get a huge return. But more to the point, Collatus knew that there was a very real possibility that the company might be sold for less than $30 million. I mean, it was a small investment advisory company. And again, they're not a fund. They have funds. In fact, Collatus is still invested in some of their funds. But what's wrong with that is that the circumstance is like the guy in the coffee shop who lives down the street. It's not unexpected that you're not going to get more than what you put in. A minority shareholder in that position who recognizes 7 years earlier, even if we sell this company for $30 million, they had a lot of non-preferred shareholders who didn't get their money back. And until they did, the preferreds were not going to get more than what they had put in. And all of that was sort of explained in both the example and in the text of the decision. So, I mean, it was drafted in such a way that we felt as if in a Superior Court session where they're busy with criminal matters and other matters, and it would be very hard sometimes to address at this level. So I moved it into the BL. They didn't oppose it. They didn't say anything about it. After Judge Davis granted the protective order motion, and I know he must have looked at the motion to dismiss because he would not have granted a protective order to shut down all that discovery. There were 4 depositions set for December. And it wasn't just to look at the narrow categories of shouldn't I be getting more. But I mean, every time someone gets less than what they expect on an investment, that doesn't give them a basis for saying, well, I expected to get more, so I want to investigate all these operations. I'm not sure that would be enough for a minority shareholder to get books and records, even if they were a member, because there's a Delaware standard. I mean, threshold's not that high, but the point is, in 10 years, he never did it. If he claimed in the complaint, I was reading the complaint, he said he's claiming
Before the merger, there'd be necessarily no, why would he be prompted to?
Well, he was claiming in the complaint that he hadn't gotten distributions during the course of the company's operation over the previous 10 years. That was one of his claims. Certainly, he made the claim about he expected to get more than $500,000 on the return of the merger, but that's belied by the amendment that happened 7 years earlier. I mean, I could start an investment advisory firm tomorrow if I had the licenses. It doesn't mean I'm going to make a ton of money in the investment advisory firm.
But just based on a fundamental fairness issue, maybe, I put $500,000 in. And I know time is of the essence, but I want to make sure I understand this. And years go by, and I've agreed that if it sells under $30 million, I'll be lucky to get my $500,000 back, right? And take it back. Was there, once the merger occurred, did Collados, if I'm mispronouncing the name, did they get the valuation so that he could say, well, you know what, I agreed to the fact that if it was valued under $30 million, I'm only going to get my $500,000 back, period. So that I feel like I got treated fairly, that everybody was treated the same.
See, that's the critical aspect. This is not a partnership. It's a limited liability company.
So the answer is no?
The answer is no.
But he's not entitled to it.
You put your money in and you take your chances. In fact, the Delaware case law that I was looking at just before the argument is, if you're a minority shareholder, even if it's not in the LLC agreement, and of course on that point we all recognize that the LLC statute in Delaware is like the UCC. It fills in where you don't need a provision that says the member's interest can go. The right to do a merger carries with it the right to what they call defease the minority shareholder's interests. And it's arguably a harsher rule, of course, than in partnerships. But the unfairness here, from our standpoint, was not to the plaintiff, it was to the defendants. I mean, Dr. Cooper does not, looking at a multi-million-dollar lawsuit or a large lawsuit after having finally sold her company, wanting to be subjected to depositions, and I was conscious of that. I mean, maybe we should have a rule in law, do no harm, as they do in the medical profession, my brother's in, but these litigations are not harmless to the defendants. And Rule 12b-6 and Rule 56 are designed to enable one to walk through these steps the way we did, and the protective order as well. And we felt that the business litigation session handled it the way it should, and that the result was correct, and that their decisions should be affirmed for that reason.
All right. Thank you for your argument.
Thank you very much.
See no further questions. Thank you both very much. Okay, that's our last case for the day, so the court will stand in recess.